The history of race discrimination in employment in education sector is a complex and deeply ingrained issue that spans many decades. Despite 140 years of protective statutes and constitutional amendment aimed at addressing this problem, race discrimination in employment continues to persist. This enduring challenge has led to numerous lawsuits being filed under various legal provisions, including the 14th Amendment, Title VII, and Section 1981. The 14th Amendment to the United States Constitution, ratified in 1868, is a cornerstone of civil rights law and addresses issues of equal protection under the law and due process. The amendment contains several key clauses, but the Equal Protection Clause is particularly relevant in the context of discrimination. It states that no state shall deny to any person within its jurisdiction that equal protection has been interpreted by the courts to prohibit discrimination by government entities or state actors based on factors such as race, ethnicity, or national origin. Title VII is a key piece of federal legislation enacted as part of the Civil Rights Act of 1964. It specifically addresses employment discrimination issues in the private sector and certain public sector employers. Title VII prohibits discrimination based on race, color, religion, sex, or national origin in various employment practices, including hiring, firing, promotion, compensation, and other terms and conditions of employment. It established the Equal Employment Opportunity Commission to enforce those anti-discrimination laws. Under Title VII, it is illegal for an employer to refuse to hire someone because of their race or to create a hostile work environment. Section 1981 is relevant in cases where either race or ethnicity discrimination is alleged in the creation, execution, modification, or termination of contracts. It also includes discrimination in the enjoyment of all benefits, privileges, terms, and conditions of the contractual relationship. This means that any form of discrimination related to employment contracts, whether it's about the initial recruitment and hiring process, ongoing evaluations, promotions, terminations, or even inquiries on job applications, it's strictly Section 1981. Unless a school district is explicitly directed by a court order designed specifically to address a past incident of racial discrimination, the district cannot favor or penalize any applicant or employee on the basis of race. This principle aligns with the broader legal and ethical standards in employment practices. Let's consider a scenario where a candidate for a teaching position or a current employee believes their race influenced a hiring or promotion decision. They often claim disparate treatment. Disparate treatment refers to instances where individuals are treated differently specifically because of their race, which is illegal under federal and state laws. For a claim of disparate treatment to be substantiated, there is a requirement for strong evidence showing intentional discrimination. This is often challenging. For example, if an employee is passed over for a promotion and they suspect racial bias, they must provide concrete evidence that race was a deciding factor in the decision-making process. What does concrete evidence mean here? It means proof that race was a significant factor in the employer's decision-making process. This evidence must be strong enough to demonstrate that the employer's stated non-discriminatory reasons for their decision are not genuine, but are instead a pretext or excuse for racial discrimination. For example, in emails, memos, or meeting notes, racial bias is explicitly mentioned in relation to the promotion decision. If there is an email from a supervisor expressing reluctance to promote someone because of their race, that's a direct piece of evidence. An employee also needs evidence to establish a pattern of discrimination. The evidence must show a consistent pattern of the employer making racially biased remarks or decisions. This could be previous complaints of racial discrimination against the employer or a history of racially motivated decisions in the organization. Other evidence is also needed, such as comparative evidence demonstrating that employees of a different race with similar or lesser qualifications, experience, or performance were promoted over the employee. In defending race discrimination claims, employers, including school districts and higher educational institutions, typically present non-discriminatory reasons for their employment decisions. They range from qualifications, experience, to performance metrics. The challenge for employees is to prove that those stated reasons are merely a pretext for underlying racial discrimination. Here is a case. In Riley v. Elkhart Community Schools 2016, Riley was an African-American teacher at Elkhart Central High School since 1980. She was named the district's Teacher of the Year in 2010. On top of that, she held an administrator license and was working towards her doctorate in education. However, Riley's journey has not been all smooth sailing. Between 2005 and 2013, she applied for 12 different positions in the school district, but none of the applications were successful. She repeatedly missed out on promotions. For example, in 2007, Riley aimed for an assistant principal role at Elkhart Memorial High School, but was passed over for Carrie Anderson, a white candidate. This pattern repeated over the years. She applied for different assistant principal positions and coordinator roles, but each time the job went to someone else, often white or significantly younger. In 2010 and 2013, when Riley applied for a coordinator position in an after-school program, the school district again chose white males over her. Then in 2012, despite being interviewed, she was overlooked for assistant principal position in favor of other candidates, including a younger white male and an African-American woman. Frustrated and feeling that her race, gender, and age might be factors in those rejections, Riley took action. In May 2011, she filed a charge with the Equal Employment Opportunity Commission alleging discrimination. After getting the green light from the EEOC, she stepped into the federal court in July 2012, making her stand against discrimination and harassment. The court noted that in some of Riley's claims, she failed to present sufficient evidence to raise a presumption of discrimination. For example, the 2009 assistant principal position went to an African-American woman. Riley could not show the position went to someone outside her protected class. For the rest of the claims, Riley failed to produce sufficient evidence of pretext to overcome the school district's legitimate non-discriminatory reasons for not promoting her. For the 2012 assistant principal position, the school district provided affidavit evidence from Krista Hutchens, a member of the screening committee, stating that the committee believed other candidates performed better during their interviews. Specifically, Hutchens said their answers related directly to improving the schools they would be assigned to, which matched up with the factors the committee was looking for, including communication skills and the potential for professional growth. Meanwhile, Hutchens stated that Riley tended to criticize without providing solutions in her interview responses. Moreover, the school district submitted the screening criteria the committee used, which showed that length of service in the school district was actually the least important factor in their decision-making process. So Riley's greater seniority did not necessarily make her more qualified. The court stated that Riley did not provide any evidence to contradict Hanning's statement or the legitimacy of the criteria used by the screening committee. Simply having more years of teaching experience compared to other candidates was not enough to establish Riley was better qualified for assistant principal positions, which were administrative rather than teaching roles. Similarly, for the 2007 and 2009 positions, the evidence showed Riley and 3 other candidates all obtained their administrative licenses around the same time. So they had comparable administrative credentials and experience to Riley. The main difference Riley pointed to was that she had more years of teaching experience and seniority in the school district. But again, more seniority alone does not prove an employer's explanation is a lie or cover-up. Without evidence suggesting she was clearly more qualified for the administrative roles at issue, there were no grounds to second-guess the school district's hiring decisions. Riley did not produce evidence that she was so favorably qualified compared to the people promoted over her that discrimination was the only reasonable explanation. The court set a high bar for the quality of evidence needed to constitute a pretext and determine Riley's evidence fell short. Here is a case in which an employee was able to establish a viable claim for race discrimination in the workplace. In Hutchens v. Chicago Board of Education, 2015, Joyce Hutchens, a Black woman who had been a team leader in the National Board Certification subunit of the Professional Development Unit of the Chicago Public Schools. She had a key role in supporting teachers aiming for National Board Certification at her school. Despite a district reorganization of the Professional Development Unit, she continued this work along with helping new teachers. Her new supervisor after the reorganization was Karen Cushion. Then there was Deborah Glowacki, a Polish-American who was another curriculum facilitator in the professional development. Glowacki had a role similar to Hutchens, but with different teaching experiences. Hutchens had an impressive background, teaching in public high schools and even running her own training firm for a while. She even won a Hall of Fame award for her entrepreneurial work. Glowacki's experience was primarily in elementary education, both in Catholic schools and public schools. Interestingly, despite their similar roles and Hutchens' longer tenure, Glowacki ended up earning more. In 2009, their department underwent changes, and both Hutchens and Glowacki's positions were eliminated. However, Glowacki was taken off the layoff list and kept her job, but Hutchens was let go. Hutchens felt this was not fair, especially considering her experience and qualifications, which included 2 master's degrees and multiple certifications. She had even received accolades for her innovative teaching methods. On the other hand, Glowacki's qualifications seemed less extensive. The decision to keep Glowacki over Hutchens raised questions. Could it be due to race or other factors? Hutchens had been part of the team longer and had a more robust resume. The person responsible for the layoffs, Alan Anderson, claimed he chose Glowacki because her familiarity with the National Board Certification Program. But this was puzzling because Hutchens had been deeply involved in that very program. It turned out Anderson had been given incomplete information by Amanda Rivera, the director of the Professional Development Unit. Anderson later admitted he did not know about Hutchens' extensive qualifications, which could have been critical in making a fair decision. Hutchens filed a lawsuit against the school district, claiming race discrimination. The Seventh Circuit Court of Appeals concluded that Hutchens was better qualified for the job than the other candidate and that race may have been a decisive factor in the hiring process. The court noted that Hutchens presented evidence demonstrating that her own skills and qualifications were superior. For example, Hutchens had strong educational credentials, including 2 master's degrees compared to Glowacki having just 1. Hutchens also had additional graduate coursework and certifications that Glowacki did not. Hutchens had 11 years of teaching experience in the school district compared to 7 years for Glowacki when factoring her parochial school time. Hutchens taught at both an elite academic high school and a tough alternative school, showing a wide range of experience. Hutchens also received awards like Teacher of the Year and a Business Entrepreneurship Award. She also led a 2008 project to recruit minority teachers. The evidence shows strong initiative and leadership. Writing samples from Hutchens' court findings showed clear writing talent. Hutchens' co-workers also testified she had strong writing ability and edited others' work. She was a journalist, and then she was always asked to write the talking points for Arne Duncan, former CEO of the Chicago Public School System, later U.S. Secretary of Education. The co-workers' testimony also directly refuted claims by the supervisor and the PD unit director regarding Hutchens being difficult to work with and lacking collaboration skills. On the other hand, the school district, the supervisor, and the PD unit director failed to produce documentation that could have corroborated their testimony. For example, the supervisor and PD unit director referenced documents, charts, and evaluations alleging deficit performance by Hutchens, but none were produced. For example, Rivera testified that she had known about issues with tardiness of Hutchens, but she did not say how or from whom she had acquired this knowledge. She did not name a single person who had informed her about Hutchens' alleged tardiness. The failure to back up accusations with documentation would make a reasonable jury skeptical of a tardiness accusation. The lack of documentation and shifting explanations could suggest pretext. Then there was Anderson. Anderson being Black does not imply that Anderson's decision to lay off Hutchens rather than Glowacki could not have been discriminatory. In fact, Anderson had never met Hutchens, and there is nothing to suggest that he knew her race. Moreover, he was, according to court, the cat's paw, which is to say, an unknowing tool of Rivera. Anderson admitted his knowledge was based entirely on what Rivera told him. He had never met or even heard of Hutchens before, showing the choice was made in absence of complete information. And Anderson's racial identity did not preclude discrimination in the process. As a result, the court concluded that Hutchens was better qualified for the job, and she was a victim of a school district's error, ineptitude, carelessness, or personal like or dislike. The final decision on whether racial discrimination occurred would be up to a jury to decide, considering all the evidence presented. The issue of race discrimination in employment, as exemplified by the cases I introduced today, serve as an important reminder of educational administrators of the responsibilities inherent in their roles. Administrators are tasked with making decisions that not only shape the careers of educators, but also set the tone for institutional values and practices. Review the hiring, promotion, and termination policies in your organization. Observe to see if the screening procedures and reviews are handled haphazardly, undermining fairness. Stick closely to standard HR practices. Avoid even the appearance of bias or favoritism. Rivera's omission of information about Hutchens opened the door to accusations of discrimination, whether founded or not. Promote full transparency around hiring and promotion. Seek input from different stakeholders when making decisions. Anderson's reliance solely on Rivera's opinion showed the dangers of a limited perspective. Gather wider feedback. Also, carefully weigh seniority and experience. The cases I introduced highlighted disputes around weighting factors like years of service and credentials. Be clear internally about priorities up front. It's important to have clear policies, documentations, and evidence trails, especially for sensitive decisions around hiring, promotion, and termination where accusations of bias may arise. Follow good practices around transparency, objectivity, and record keeping can help you avoid racial discrimination accusations. There may be more complex dynamics at play in race discrimination lawsuits. Please share any feedback or thoughts you may have. Thanks for watching, and I'll see you next time.